What you think?
Excuse
Do
me.
I have before me a plea sheet that indicates that the defendant would be pleading to count two?
This is a plea deal in action, and it's already shaping the entire outcome of the case. One charge gets dropped, the other sticks, and just like that, the risk of a full trial disappears. But here's the real question. Is the defendant taking responsibility or just avoiding something worse? Because in court, a deal like this can be smart.
Violence. Upon a successful plea to that charge, the 93-day offense. Upon a successful plea to that charge, count one would be dismissed. There is a sentence agreement to sentence under 7694.
That's my understanding as well, Your Honor.
All right, very good. Let's have him sworn.
Mr. Wright, you solemnly sworn to affirm the testimony you're about to give will be the truth, the whole truth, but the truth shall be God.
Yes, I do.
What's your name?
Glenn Bradford.
Sir, it is this court's understanding you're going to plead guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that? Sir. But also, sir, that while in take, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B.
Right here is the turning point. He's officially giving up his right to trial. No jury, no cross-examination, no defense strategy. Everything now depends on this one decision. And this is where it gets real for viewers too. What would you do in this situation? Take a guaranteed outcome.
Still wish to plead guilty?
Yes, Your Honor.
That charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of a defense.
Yes, Your Honor.
Signed an advice of right form, is that correct?
Your Honor.
Question regarding any of those rights?
None.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights in that form.
Yes, I do, Your Honor.
You understand you're giving up your right to appeal of right.
Your Honor.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today to get you to plea? Anybody threaten you or coerce you? You're doing this voluntarily, of your own free will,
Yes, Your Honor.
and also because you believe that you're indeed guilty of this offense, sir?
Your Honor.
On August 7th, 2025, at the location of 1043 East Forest Avenue in Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do on that date involving a Gabriella Bradford that makes you think that you're guilty?
Gabrielle.
Gabriella,
would be my daughter.
your daughter. Okay.
Me and my wife had an argument and I shoved her.
Okay. What's your wife's name?
Gabrielle.
Gabrielle Bradford. Oh,
E at the end.
got it. I see. All right. And you shoved her. You did that on purpose, sir? You didn't have her permission to do that.
I did. No, Your Honor.
And there's been respect. Sir, if I accept your plea, that you commit misconduct as defined by the Michigan court rules between the time that I accept your plea and the time of sentencing, you would not be entitled to withdraw your plea. You understand that, sir?
Your Honor.
And the court would not be bound by any sentence evaluation or recommendation. You understand that? All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
None, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be June 1st, 2026, 10 a.m. before Judge Washington. Bond with its conditions will continue. See, I told you.
Prosecutor will get it.
Do it.
Just Washington.
Okay.
Call me if you have any questions.
Do it. Just, you just need to have more faith in me.
And that single sentence, I shoved her, just sealed the case. No long testimony, no dramatic back and forth, just a direct admission. That's how powerful a guilty plea is. It replaces an entire trial in seconds. But don't forget, the story doesn't end here. Sentencing is still coming.
Oh, well, maybe not. No, June 1st. Court calls the case, People versus Matthew King.
Good morning. Joy Gaines, Senior Assistant Public representing Mr. King, President. Would you state your name, please?
Tony King. How you doing, Mr. I'm doing great, Mr. King. How are you? Good. What do we do?
Your Honor, we do not have discovery yet as of yesterday when I met Mr. King. Miss Sunda, I'm assuming, because I emailed her at the same time regarding his as the other clients, that we will have it. Regardless, Mr. King wants to schedule the preliminary examination, and he is very much aware of where we are in this process. He is adamant that he wants to schedule the preliminary examination.
Your Honor, at this point, I would be objecting to that, given that I have come to find out there is more discovery. There's a second venue involved in this case that does have additional video surveillance of the actual assault that occurred in this case. There's going to be more discovery because I was planning to address bond today, so there will be jail calls that could be leading to other charges in relation to this case. So at this time, there are two things in play here that I do not have yet, and that defense does not have yet, that I think would be very important for this case, along with another follow-up interview with the victim of this case as well.
My client still wishes to go forward with the preliminary exam as soon as possible.
Understands that if all of that's not there, or if we start the preliminary examination, then it could be adjourned if people aren't entirely ready to go. It's fine. Pardon?
He said that's fine, Your Honor.
Been to jail 2 weeks. I ain't did nothing wrong. They always try to do.
Well, Miss Queen, let me explain to you though. Problem's going to be you may be in there longer, that, and nobody can go because they don't have the stuff. Your counsel can't even advise you to what you're going to do. I mean, so that's all I'm saying.
Mr. Simpson, can I say something to him?
Well, I was going to say, I know that you and I talked about that, and you understand that, and you are anxious to get this case moving forward.
Yes, I get none of these days credited. I've been in.
Well, sir, you know,
He's on a parole hold.
Nobody behind.
that the discovery that you have now, you can get over to.
It was sent yesterday, Your Honor.
It was sent yesterday.
The link was sent over yesterday. I'm awaiting further steps along with the surveillance video from where the actual assault occurred, and then potentially this case would also jail calls that could be future charges as well.
As to the witnesses currently charged, you would at least have police officers that can testify, correct? Because I'm going to do something with the state because everybody seems to be in a hurry. So I'm going to set an in-person preliminary examination. I'm going to set it for April 28th, 2026. A few days. Hang on. 9 a.m. That's before noon.
Thank you.
As bound.
Yeah, some of my agents seem arranged to consider making calls to his family that his sister and his mother. In these calls, he says, "My son doesn't need to come to court, man. You don't need to come. Talk to his mama. Talk to his mama. You're right there. If you want to help her nephew, you should go and talk to his mama. That's what I said. It's going to kill him in the end. She's supposed to be on it. So I know what I would do. For the same time that they need to talk to the victim's mother. The victim is his minor son. So he's asking them to talk to the victim's mother to try and get him to not come to court and to guilt him into coming to testify against his father. So I think this could be leading to charges of witness interfering in the future. And we've not had a chance to go through all of the jail calls. These are just a few. Right. And Mr. King is also on parole for a witness intimidation interfering as well.
Your Honor, Mr. King did indicate to me that because this involves a family situation, that he has spoken to his mother and his sister. He has not spoken to his son or his son's mother, but his own mother. And everyone is aware of the allegations. He indicated that he does, to me, he indicated that he does have concerns about his son having to come in and testify and amplifying any potential issues between them. But he said to me when we were discussing that I did not have the discovery when I spoke with him yesterday, that he is prepared for his son to come and testify. So without more context, I think there may be more context than the statements alone are giving at this time. So the preliminary exam is April 28th. I know that you typically cease phone calls. I just wanted to reiterate that he has not had any phone calls with his son or his son's mother, but the exam is on
directing people to contact them. Same.
Well, I'm
Cannot have only direct contact, Ms. James, as you know, can't have indirect contact.
correct. I'm not disagreeing with that. I'm just saying that based on our end terms of there may be more that we may not be getting the whole conversation in context, given how he told me the conversations with this family judge.
What I will do is I'm going to read the people's request. The defendant's phone privilege is affected hereby ordered revoked. Hold on, sir, do not do that.
You always take my phone. I haven't did anything wrong, Mr.
Sir,
I haven't did anything wrong.
want a hearing on it? Because I'll have to listen.
Let's do a hearing today,
Want me?
because I need to talk to my family. I have things going on.
Sir,
I want to do one today. Like you taking my phone, Mr. Simpson, and I ain't called them. The thing was, don't talk to my son. I haven't talked to him. I haven't contacted any of them.
bond conditions were that you cannot have third-party contact or direct third-party.
I haven't.
Okay,
I haven't, sir.
are you going to listen to me? Because if you're not going to listen to me, then I'm not going to listen to you. Okay, you can shake your head all you want. I'm just going to leave it there. We'll see you on Tuesday. You know, you respect me, I'll respect you, but I'm not going to do it. Yeah, we're gone. We're done.